Well, welcome everyone to today's ACLU Leadership Forum on the Future of Reproductive Rights. As noted, I'm Yasmin Cader, and my pronouns are she, her, and hers. And for those of you I haven't had the pleasure to meet, I am the director of the ACLU's Trone Center for Justice and Equality. And the center is focused on eradicating racial injustice and rooting out deeply entrenched problems in the criminal legal system, analyzing all of these issues through the lens of those who live at the intersection of race and poverty. I also help to oversee our abortion criminalization defense initiative, which is set up to protect providers and helpers from potential criminal exposure, and of which we're going to have a chance to talk about more later. What we're seeing is our political landscape changing rapidly, including with the news that we all received this weekend. And as a nonpartisan organization, what the ACLU does is serve as a steady ship in these ever-changing waters, prepared for all of the potential opportunities as well as challenges that we may face, depending on what happens in November. Abortion access has and will continue to take center stage. So along these lines, today's conversation takes place against the backdrop of the threat of criminal prosecution of those who seek abortion care, as well as the prosecution of those who help them and those that provide such care. We've already seen and will discuss here today how these laws disproportionately impact Black women who also bear the brunt of high maternal and high infant mortality rates. We also know that trans and non-binary people face particular vulnerability in the criminal legal system and will suffer disproportionately from criminalization. But the ACLU is, as always, prepared to continue the fight. And I am joined today by my warrior colleagues who are working on the front line and who will provide you with an overview of the abortion rights landscape. They will offer an inside look into our strategic thinking and planning as we all head into a critical political moment for abortion rights, for reproductive freedom, and for reproductive justice. So I would ask my fellow panelists to turn on their cameras and wave hello, and I'd like to introduce them. First, we have Brigitte Amiri, who is the Deputy Director of the ACLU's Reproductive Freedom Project. Next, we have Victoria Lopez, who is the ACLU of Arizona's Director of Program and Strategy, and I can fondly say also an alum of the Trone Center's National Prison Project. My colleague Lauren Johnson is not here today, unfortunately, because she is traveling back from a successful day in court, and I'm going to regale you with that victory later on. Lauren is the head of our Abortion Criminal Defense Initiative. To those of you who have joined us, we've carved out time at the end of the program to answer your questions, but please feel free to drop any of those questions you have in the Q&A at any time during our conversation, and we will get to as many as possible. I believe my colleague Makiba is dropping those instructions into the chat right now. And I'd just like to start our conversation today noting that this is an off-the-record conversation. So if there's a journalist among us, we understand and ask that you understand that nothing that's said here is for attribution or citation, because it's really important for us to be able to have an intimate forum, a place for a truly candid conversation, and a safe space for you to raise your questions. So I'd love to start conversation with my colleague Brigitte and ask, let's bring some data to the context of what's happening. I know that everything is a moving target, but as of today, how many states have near or total abortion bans?
Thanks so much, Yasmin, and thanks to everyone for being here. So right now, about 16 states have total bans on abortion or abortions at about 6 weeks in pregnancy, which is a time before many people even know they're pregnant. That number keeps changing, however, as we win or lose a case. And unfortunately, I think that number is going to climb to 17 when Iowa's 6-week ban is potentially going to take effect next week. We're also seeing lots of other restrictions on access to abortion, such as barriers to obtaining care outside of one's home state. So, for example, attempts to limit people traveling from a state where abortion is banned to a state where abortion is legal, and also attempts to prevent healthcare providers from providing referrals to abortion in places where it's legal when it's banned in their state. We're also seeing attempts to remove mifepristone, which is one of the medications used in medication abortion, which takes medications abortions are most of the abortions that happen in this country, and we're going to talk about those attempts later. We're also seeing attempts to establish fetal personhood in litigation or legislation, and if that happens, then if fetuses and embryos are people for the purposes of the Constitution, that would effectively be a nationwide abortion ban. So right now, the ACLU's Reproductive Freedom Project has about 20 pending cases, and about half of those are in state court under state constitutions, because state constitutions can provide independent and sometimes greater protection than the federal Constitution.
You know, in some ways, it's really hard to believe that it's only been 2 years since the Supreme Court overturned Roe and opened the floodgates for these state abortion bans to occur. I'd love to tap our panel here to speak to the realities on the ground and hear some of the stories from the front line. And I'd ask Victoria, can you kick us off?
Yeah, thanks so much, Yasmin, and thanks to all of you for being here, and to my national colleagues for holding this space and for the invitation to be here today with you all. Following the Dobbs decision, Arizonans, like many across the country, faced an incredibly complex and confusing legal landscape on abortion access. And to take a step back, even before Dobbs, Arizona lawmakers passed some of the most restrictive bans on abortion in the country. And so then following Dobbs, our former attorney general decided to go to court to reinstate an abortion ban dating back to 1864. So that was what we were facing here in Arizona. Going back to a time when 27 men passed this law before Arizona was even a state, at a time when America was at war over the right to enslave and own human beings, at a time before women could even vote. And this 1864 ban provided no exceptions for rape or incest. It allowed abortions only if the mother's life was in jeopardy. And the 1864 ban also allowed for a 2 to 5 year prison sentence for doctors who provided abortion care. So an incredibly extreme landscape in Arizona. And for the past 2 years, we've been working across the organization to fight back against this 1864 ban. We've been in court along with Brigitte's colleagues at the National Reproductive Freedom Project and with partner groups fighting to strike down that 1864 ban in the courts. And as we know, even when you give it all that you've got, the courts get it wrong. And so in April of this year in Arizona, in an absolutely shocking and devastating decision, the Arizona Supreme Court allowed the 1864 ban to be reinstated. And now I'll tell you, I still struggle with the words to accurately convey the sentiment in this state following that decision. But what I can say is that it was a pivotal and a collective moment of outrage in Arizona. And we saw that turn into immediate action with mobilizations across the state and demands that our government take immediate action on this 1864 ban. This outrage also created an important political moment in a critical election year. revealing that the 1864 ban was even too extreme for some lawmakers, particularly in an election year. And that outrage and that momentum is what points the way forward for us in Arizona.
Well, I mean, in Arizona, you are pointing the way forward for not just you, but for everyone, because you are so inspiring and really heartening to hear that that reinstatement of that archaic law may have truly been a bridge too far for some, even in the anti-abortion movement themselves. Well, as I promised at the top, our colleague Lauren Johnson, who's not here, defeated a motion to dismiss a case that was brought in a state or in a federal court in Texas. And in that case, our client, Lizelle Gonzalez, was arrested, she was jailed, and she was charged with murder after a medication abortion she had in 2022. Lizelle, who is 36 years old and a mother, is now suing the law enforcement officers and prosecutors who knowingly misrepresented the facts and purposefully disregarded her rights. We joined this case to represent Lizelle, who through her bravery is holding officials accountable in the fight against criminalization outcomes. And through this case, we're linking arms with her and her other lawyers on the ground and our affiliate to send a clear message to other district attorneys and prosecutors that the ACLU is watching and we are showing up. So circling back to you, Brigitte, what other kinds of attacks on reproductive freedom are you seeing?
Yeah, so we're seeing a firestorm of litigation related to abortion access. And to be clear, the other side's endgame is to ban abortion nationwide. But as I mentioned before, it's not just about abortion. The other side is attacking lots of reproductive freedom, including the right to IVF and the right to contraception. So it's really the full panoply of our bodily autonomy that we're seeing attacks on. We've even had to go to court to challenge the de facto ban on freestanding birth centers in Alabama. These are healthcare centers that provide safe and welcoming environment to people who are giving birth. And mind you, Alabama is one of the states that have banned abortion, and now they're taking away safe birthing options. Notably, Alabama government officials did not begin to enforce their de facto birthing center ban until 3 Black women, including our clients, began to open their health centers. But we're pleased to report that we secured a preliminary injunction paving the way for the healthcare centers to open, and the case is ongoing now. But also, it's important to remember that if allowed to stand, the de facto ban would disproportionately affect Black women in a state with very high, the 3rd highest maternal mortality rate and the 6th highest infant death rate in the United States.
I have to tell you, Brigitte, and I've said this before, that is one of my, that case, as they say, gives me life. I appreciate it so much. It just, to me, exemplifies how we are coming at this from so many angles and also centering the people who are most impacted. So gratitude from me to you. So now we've covered the abortion landscape and what we're up against. So I'd like to dig in now to our ACLU response plans and how we're marshaling each of our powerful muscles, our C3 litigation, our C4 advocacy arm, our coast-to-coast network of affiliates, and our deep community partnerships. So let's start with litigation. Brigitte, you mentioned 20 active cases. We also saw 2 cases in front of the Supreme Court this term on this issue. And in the first of those, the court addressed an attack on medication abortion. And in the second, the court temporarily restored hospitals' ability to provide emergency abortion care. Can you please shed light on these decisions and put these cases in context and perspective for us?
Sure. So I think everyone knows that in 2022, the Supreme Court decided a case called Dobbs versus Jackson Women's Health, which overturned Roe versus Wade. And that meant that states were free to ban abortion. And we saw a number of states try to ban abortion. And we went to court in about a dozen states to try to block those bans under state constitutions. Because as I mentioned before, state constitutions can provide independent and greater protections than the federal constitution. And a number of those cases we lost, unfortunately, and abortion was allowed to be banned. And a number of those cases are still being fought, and we've been able to hold back abortion bans in a number of states and in Guam. So I want to talk about the cases that you mentioned that reached the Supreme Court, though. There are two cases. So the first case is Alliance for Hippocratic Medicine and versus the FDA. And it's a case brought by an anti-abortion organization that was an attempt to take mifepristone off the shelves. And as I mentioned before, mifepristone is a medication used in the medication abortion regimen. And currently about 2/3 of the abortions that happen in the United States are medication abortion. It's also important to note that mifepristone is also used for miscarriage care. So it would have devastating consequences if all of a sudden mifepristone was removed from the shelves. In this case, the court sidestepped the ultimate merits question of whether the plaintiffs could prevail in their challenge to remove mifepristone from the market. And instead, they said that the plaintiffs lacked legal standing to pursue their case. So the result is that the decision preserves now the ability for people to rely on medication abortion under the patchwork that has existed since 2022, given the states have banned abortions. But the case will continue in the lower courts because the lower court allowed certain states that are hostile to abortion to intervene in the case. And there's a question about whether they will be able to pursue the merits. So the threat to medication abortion is not over by any means. The other case you mentioned is Idaho and Moyle versus United States. And it's a challenge brought by the federal government against Idaho because Idaho's abortion ban, the only exception was a very narrow life exception. And the federal government said that that law was preempted by a federal law called the Emergency Medical Treatment and Labor Act, EMTALA for short, which says that hospitals that receive federal money through Medicare and Medicaid must provide emergency care. And that includes emergency abortion care. And so the case was about whether Idaho's narrow exception for abortions, just the life endangerment, was not broad enough to encompass EMTALA. The Supreme Court ultimately refused to clearly affirm the right of people to obtain emergency care under EMTALA, and instead said that they took the case up too soon, and the case should go back to the lower court for further proceedings. So eventually, the case could come back up to the Supreme Court. As with all of these court battles, it's really important to pull back the lens and think about the bigger picture. As the ACLU's legal director, David Cole, says, constitutional law depends upon all of our involvement and engagement as citizens committed to the constitutional values we care about through organizations like the ACLU. We, the people, can and have succeeded in shaping the law to reflect our values. We saw this in the context of same-sex marriage, for example, which was a decades-long fight that eventually reached the Supreme Court and established the right in 2015. So the fight for reproductive rights is ongoing, and we will never stop fighting.
We are truly in it for the long haul. And in addition to the long-term commitment we have, we really benefit. And, you know, Victoria, I'm so glad that you're here as well, because having a presence in every single state, in the District of Columbia and Puerto Rico, sets us apart. The ACLU partners with all of our affiliates to make sure that we are staying on the front line of the struggle to ward off attacks aimed at criminalizing access to essential care. And again, the ACDI, or the Abortion Criminalization Defense Initiative, and the ACLU of Maryland recently stood up and filed an amicus petition to the Maryland Supreme Court in the case of Moira Akers versus the state of Maryland. Now, that case involved a woman who said her child was born stillborn, but even so, the state prosecuted her for second-degree murder, relying on so-called evidence that Ms. Akers allegedly researched pregnancy termination options online and was advised by a doctor about abortion. Now, if this type of evidence is allowed and is brought into court, it's going to have a broad, chilling effect and diminish all Marylanders' rights to decide whether to terminate a pregnancy. They may now fear that simply contemplating ending a pregnancy could be used against them in a criminal court as proof of guilt. So, with all of this headline grabbing litigation that we're involved in, I think it's really especially important now to pivot and talk about the hard work that's happening in other contexts too. So I'd like to transition, if we may, to what's happening outside of the courthouses and in our legislatures and at the ballot box, and with the effort to move hearts and minds. So far, 7 states have affirmative abortion rights measures on the ballot, including Arizona. Victoria, can you walk us through some of your legislative and advocacy priorities?
Absolutely. So I'll back up first because I want to talk about legislative advocacy and other, but I do need to weave in our litigation piece here a bit too, because we are really leveraging all of it in this fight.
I don't mind. Go ahead. I will never object to you talking about litigation.
It's all part of the story. So our team in Arizona has been fighting back at the state legislature and in the courts for years, right? Going back to that 1864 law, while our partners litigated against the 1864 ban in the state courts in Tucson, the ACLU filed a parallel case in the state courts in Phoenix, right? And we were able in that case, that challenge to the 1864 ban, to do some important advocacy behind the scenes. And this isn't widely known, but it was really a strategic litigation point in this case where we managed to negotiate a non-enforcement deal with the former Attorney General. That non-enforcement deal gave us 45 days. It gave us, our physician clients, and our communities some breathing room in case the courts decided to allow that 1864 ban to take effect, which, as I just mentioned, the court did allow it to take effect. So the simultaneous efforts of our litigation and this negotiation around the enforcement allowed us to be in the state house and led to the repeal of the 1864 law, right? With a handful of Republicans voting with Democrats for the repeal. And then our governor, Katie Hobbs, signed that bill repealing the 1864 ban. This is huge, right? This is huge. And that repeal will take effect on September 14th, just a few weeks before our judicial hold of the enforcement of the 1864 ban runs out on September 24th. So all of this to say, because of our legislative advocacy, because of community pressure, and because of our litigation strategy, Arizona will not see one day of enforcement of that 1864 ban. This is the power of our work. This is the power of the ACLU. And there's lots to say about the political piece too. The governor's move makes sense, right? Like many other states, legislators and the courts in Arizona are out of step with the will of the people. We know that the majority of Arizonans support safe and legal access to abortion care. Full stop. right? We also know that extremist attacks on abortion have galvanized activists and voters in Arizona. I noted, just the pivotal and collective momentum that we have felt in our state. We saw this during the legislative session while lawmakers were debating the repeal of the 1864 ban. Imagine needing to even have a debate about repealing this antiquated law. Now we have a citizen-led, a people-powered initiative called the Arizona for Abortion Access Campaign that introduced a measure to amend the Arizona Constitution to include a fundamental right to abortion and to prevent the criminalization of people who provide abortion care. And the initiative, which filed its petitions earlier this month, garnered over 820,000 signatures from across the state. This is a historic number. This is the most signatures ever collected by a citizen-led initiative. So there is no doubt that the momentum and the support behind this is because of the urgency created by the Dobbs decision and by the position of anti-abortion lawmakers in their support of the 1864 law, right? These months in Arizona have felt like a full-blown sprint. But I'll tell you, we know that the people in our state are with us, right? And we see this, and I'll share a quick story that in my Phoenix suburb, I went to cast my ballot in the presidential preference election in March, right? So even before the Arizona Supreme Court decision here. And as I walked up to the vote center, there was an older white gentleman with his, big sun hat on, sitting at a table collecting signatures for the abortion initiative. And he had a crowd of probably 10 people standing around him. And it was just so heartening and honestly brought me such pride and joy in the people of Arizona just engaging and activating and working to get this done, right? And to really just nail it down that we in Arizona deserve full access to abortion care.
Democracy in action, right? I mean, Arizona is a battleground state for the right for abortion, and it has also faced a long history of attacks on voting rights, both things at the same time. So do you see connections between these two struggles?
Absolutely. Absolutely. I mean, this is, again, one of the beautiful, joyful things about the work that we get to do at the ACLU is that our issues, our communities are intertwined. And this is absolutely the case with democracy and abortion access, not only in Arizona, but across the country. We see the very legislators trying to restrict access to abortion, also trying to suppress the right to vote, especially among communities of color, Black communities, Latinx communities, Indigenous communities in our state. So as part of our preparation at the ACLU of Arizona for this election cycle, we are really, really excited. We are on the verge of hiring our first ever dedicated voting rights attorney. Very, very exciting.
Very exciting.
Who will work with our National Voting Rights Project, a phenomenal group of folks there, to work to ensure that Arizonans have access to vote. And we're also gearing up to hire a dedicated voting rights organizer. Again, huge for Arizona, to rally our supporters and our volunteers to continue to defend and expand the right to vote, access to abortion, reproductive health care across all of our issues. And just one example of what we're dealing with in Arizona is responding to attacks on Arizona's robust vote by mail system, which has been in place since the 1990s. I remember those times. And which over 70% of Arizona voters use to cast their ballots. In 2020, 90% of Arizonans use vote by mail to cast their ballots. Plus, we have vote centers in Arizona, which allow the majority voters in a majority of our counties to drop off their ballots at any of these centers. But throughout our legislative session, we've had to fight against attacks, against efforts to scale back these common sense and widely used measures that allow people access to the ballot. Now our policy and our organizing teams are meeting with county elections officials. They're doing some data collection, and we're training volunteers so we can push back against these attacks, which we know are especially important for rural voters, for voters with disabilities, for Indigenous communities, and for many, many others across our state, right? So these populations whose voting rights are under attack are the ones who are going to be hardest hit by restrictions on abortion and reproductive rights.
You know, it's so, I mean, one, you're talking about, you remember the 90s. Well, I might remember a few decades before that, but you know, thinking about though, Arizona's abortion rights ballot initiative is really a reminder that, as you're saying, protecting abortion rights requires protecting the right to vote and requires making sure that people's votes count. In Ohio, last year, legislators attempted to subvert the ballot process itself by increasing the threshold for citizen-initiated constitutional amendments from a simple majority to 60%. And that was seen as being a targeted attempt to prevent abortion rights ballots initiative from reaching the voters in that state. And so it's really just an example how important it is to bring all of our expertise, our litigation expertise in so many different areas, our advocacy chops in all of these different areas, and bring them together to protect everybody's civil rights and civil liberties. All right. So I'd like to think a little bit about and take us back to the fact that, you know, we have been around for over 100 years, and the ACLU, I am so proud to say, is consistent and clear-eyed and steadfastly dedicated to our mission to protect and defend and expand civil rights and civil liberties. And we do this every day, and we do this under every different political leader. So we will support any executive action to defend and expand civil rights and liberties, and will stand against any executive action that threatens them. It is really a hallmark of our strategy, our commitment, and our status as a nonpartisan organization. We never let the pressure off for the fight for an America where we, the people, means all of us. So we have to be prepared for the potential landscape of challenges to, or a landscape of expansion of our civil rights and liberties under every presidential administration. So in advance of this year's presidential election, our legal and advocacy experts across the organization have identified the unique challenges and opportunities that each administration will bring, and the concrete actions that the ACLU will take in response. We've conducted this analysis for each of our priority issues: immigrants' rights, abortion access, LGBTQ justice, First Amendment rights, racial equity, and criminal legal system change. So, starting in June, we began sharing our findings in a series of memos. And we started with 7 memos, one for each priority area, with an analysis of the opportunities and the challenges presented under a potential second Trump administration. And we're turning now, and we will produce the same analysis for a presumptive Harris administration. These memos reflect a tremendous amount of analysis from our subject matter experts, and these experts provide both what we expect as well as our plans for a response for both litigation and advocacy. So you can find them online at the URL link that we're dropping into the chat. And I encourage everyone here to read them and share them widely with your personal networks. I see it's just dropped in the chat. Brigitte, you worked a lot on the ACLU's recently published Trump memo on abortion, and you're providing an analysis for the forthcoming one for the potential Harris administration. Can you share our assessment and response plans, or at least a summary of them?
Sure. So while I want to say that the ACLU has been around for 100 years, we have not been around for 100 years. We might remember the 1990s, but we haven't been around that long. So yes, you know, a second Trump presidency would exponentially increase the damage done to reproductive rights. For example, Trump and his allies have made clear that if Trump is elected, he will attempt to misuse a law from the 1800s called the Comstock Act to ban abortion nationwide. As I was listening to Victoria talk, I was thinking, what is it about laws from the 1800s that are haunting us now? Here we are. The ACLU has been sounding the alarm about the Comstock Act being used to ban abortion nationwide, and we're supporting legislation in Congress to repeal it. In addition to the Comstock Act, a second Trump administration could decimate abortion care in every state in the country if the FDA did remove the mifepristone medication that we talked about off the shelves. Certainly, Trump's allies are calling for that, and as you saw, as we talked about earlier, there's litigation to attempt to do that. A second Trump administration would also likely decimate access to birth control for people living with the lowest incomes by perhaps defunding the National Family Planning Program in this country. And also possibly the Trump administration might try to take away people's right to insurance coverage for contraception under the Affordable Care Act. So our strategy to responding to a Trump administration is not just limited to the courtroom. We will use every tool in the toolbox, as we've been talking about, going to court, mobilizing the public, legislative efforts. We will do it all to fight back against any threats by any administration to any of our reproductive freedoms.
Thank you. We are depending on you to do that. So I'd love for us to shift now to our Q&A. And I see we've been receiving questions throughout our conversation today, and we're going to do our best to answer as many of those questions as we can. But there may be some questions we can't get to today, but we will be sure to follow up after the event. So Makiba, could you please share the first batch of questions?
Sure. So we have a question that was pre-submitted from Donna S. Will you clarify what Congress can contribute to restoration of Roe and how this can legally be accomplished? A next question, we actually received a few comments about the role of religion. One caller mentioned the role of the Catholic Church to push for abortion bans, and another asked whether abortion bans could ever be challenged as a violation of freedom of religion. Can you all speak to the role of religion in our legal arguments and or coalition work? And then final question for this batch. I have heard that medical providers, OBGYNs, are migrating away from states with abortion bans. Do these states not see the harm to maternal health and medical deserts they are providing?
Did you want to start?
Sure, I'll start with the federal legislation piece and say that absolutely Congress could enact a federal statutory right to abortion. I also want to make clear that Roe was never enough. Roe was the bare minimum of what we need to ensure that people can get abortion care in this country. Everyone should be able to get abortion care regardless of where they live, how much money they make. So there are a number of different bills pending in Congress right now that are critically important and would not just establish the right to abortion as a statutory right, but remove existing barriers that have been on the books for years and years. So for example, the Women's Health Protection Act is a bill that would establish a federal statutory right to abortion and could preempt state bans and state restrictions on abortion. And then there's also a bill that would remove restrictions on Medicaid coverage of abortion, which has been a barrier to access for people who have Medicaid as their insurance. So yes, there's a lot that we can do, and everyone should have their congressional representatives on speed dial and call them and ask them to pass these really important pieces of legislation.
Get them on speed dial, get them on social media. Don't forget about email. Come with all the ways for all the things. Before turning to the question on religion, Victoria, I think I appreciate all of our questions, including those that express, the kind of, frankly, sentiment and outrage that I feel. And the question about medical providers, including OBGYNs, that are migrating from states with abortion ban. Do the states not see what is happening? Do they not understand that they're providing and creating, rather, these kind of deserts?
I mean, we know a thing or two about deserts here, right? And yes, to this question, I mean, the ACLU and the ACLU of Arizona have been really fortunate to represent some incredible healthcare providers in our abortion access litigation. And we've seen the devastating effect that these abortion bans in Arizona have had on our medical provider community, on people who provide assistance to those who are seeking abortion care, people not wanting to continue to provide care because of very real fear of the repercussions of the law. And again, the uncertainty and the confusion that has happened in particular over the last 2 years around the Dobbs decision, and then in Arizona around the 1864 ban, has been a real tough, and that's putting it mildly, road to navigate for folks who provide abortion care in Arizona. I think our role at the ACLU and the ACLU of Arizona over the last 2 years has really been to maintain focus and discipline in our legal analysis, in our communication with community members, with healthcare providers, to make sure that people understand the legal landscape and can navigate appropriately. But the impact is really severe, including in places like Arizona.
I can say, I'm going to channel Lauren right now, because I do work closely with her in terms of creating this network of lawyers, defense lawyers, well-trained criminal defense lawyers across the country in every state, but including in states such as Arizona, to make sure that they are there, that everyone knows that they're there, and that they have strong communication with the provider community to say, we've got your back. And that has been something I can say, it is not everything. We are still, to the person who put the question in the chat, facing, as you're saying, exodus in certain places. But I have heard, and I have, individual stories from provider to provider saying, you know what, I am so glad you are here, and we are responsive, and we are here. And that, I can just say, I know that I have taken calls on the weekend and at nights. I know Lauren does all the time. And it is just to be able to shore up the support from this angle, so that no one is standing alone in that context. Brigitte, can you talk to us a little bit about religion?
Yes, and so for a large part of my docket for many years, for example, we saw attempts to use religion to discriminate against people and take away their rights. And so that was seen in many contexts, and I think probably most significantly in the context of people challenging aspects of the Affordable Care Act's birth control coverage requirement because of their religious objection to providing birth control coverage to their employees. And we fought against those attacks. There are a number of cases where the script is now flipped. And so some of our affiliates, including Indiana, are involved in cases challenging abortion bans on the grounds that they violate religious freedom, that individuals have a right to make a determination about when life begins and when to have an abortion, and the state can't infringe on that religious belief. So these cases are working their way through the courts, but I think they're an important part of reclaiming the narrative of what people's religious beliefs mean to them, and to not let the other side use religion to take away rights, and instead to say, because of our religion, we have rights.
I think that's just so important. And it just also, I'm reminded of the fact that there really isn't a family in this country who our work doesn't touch positively, whether it be that we're standing up for your rights in one context or in another, that we provide that broad-based protection is something that I'm grateful. Another reason I'm really grateful to be here. Makiba, do we have other questions that we can answer?
Yes. Next question. Several Texas towns have prohibited travel for the purpose of obtaining an abortion in another state. Any litigation or action on this blatantly unconstitutional ordinance? And the next question is, how would you respond to folks who are underestimating the ACLU's role in this moment for our democracy? I have so many friends supporting politicians right now, and I question their return on those investments.
Okay, so I'm going to take the second question first, and then Brigitte, I'm going to take you the first. And I love that second question. Never underestimate the ACLU. And I mean, I say that from my heart, because again, to the point that I was making before, the fact that we are standing up for people's rights, and the fact that we are doing so from a national perspective in all of our affiliates, and that we're marshaling all of these different muscles, I just think we are an incredibly worthy investment for the short, medium, and long term. One of the muscles that we haven't explored, that we've been exploring implicitly, but not in depth, is that of our communications and the strategy behind that. The last question asked, what about these deserts of providers that are happening? Well, I can say trust and believe that the fact that these things are happening is fuel for the fire of the movement, but that requires a very astute analysis and strategy that involves communication strategy. So that is part of the muscle that we have. So I would urge your friends that they should never, ever sleep on the ACLU, and that we are a very worthy investment for the long term. So that would be my answer to the second question. But to the first about Texas, Brigitte, do you have?
Sure. And talk about return on investment. We've been here for 100 years through all different types of challenges to civil rights and civil liberties, and we've met those challenges, and we keep pushing forward. So on Texas, we're monitoring everything very closely in Texas in terms of these ordinances that attempt to prohibit people from traveling through Texas to a state where abortion is legal. And I'm going to back up and give you kind of a nerdy answer to the question, which is that just because a law is unconstitutional doesn't mean there is a mechanism to challenge it in court. So folks may remember that we challenged Texas's Senate Bill 8, which was a ban on abortion starting at about 6 weeks in pregnancy. But the only mechanism for enforcement was a civil lawsuit brought by one individual against a provider for providing the abortion, or someone helping someone obtain an abortion in violation of the law. There was no government enforcement mechanism. And the case went all the way to the Supreme Court, and the Supreme Court said, if you don't have a government defendant to sue, then you just have to wait to see how the law plays out in the civil court context. So we couldn't block the law before it took effect, even though this was before Roe versus Wade, and a ban on abortion starting at 6 weeks in pregnancy was blatantly unconstitutional. So super nerdy response that not every unconstitutional law means that we can challenge it in court affirmatively. And we are monitoring everything going on in Texas right now.
Thanks. And I thank you for that. And I want to thank everyone who's here for the thoughtful and important questions that are being asked. If we weren't able to get to your question, please email us at Leadership Forum at ACLU.org. LEADERSHIPFORUM at ACLU.org. All right. I just have to ask one more question because I want to draw on the fact that each and every one of us, everybody who was here, is a powerful actor in creating the change we want to see. So, Brigitte and Victoria, what is one tangible action that we can all take for abortion rights? Victoria, you go first.
Yeah, don't sleep on Arizona. I know we're getting a lot of attention these days, and it's because it really matters. And so plug in to, the ACLU of Arizona, follow what we're doing. There are lots of ways that folks can engage and support our work here on the ground. It's going to be a quick few months to November, and I will tell you all, I promise that we are pushing really hard to get this done. And make sure that we're doing everything we can on abortion access and all of the issues that we care about so much. So plug into the ACLU of Arizona, check out what we're working on, and send all the good vibes.
Brigitte?
Yeah, I would also say, reach out to your local reproductive rights, health, and justice community. See how you can be helpful in your community, whether it's volunteering to be an escort at a clinic to help people get in and out of the clinic or do something else. And I will just say that I'm born and raised in Michigan, and I am so proud, speaking of not sleeping on Arizona, don't sleep on any state. Growing up in Michigan, it was such an anti-abortion, anti-reproductive rights climate. And to see now today, Michigan be an abortion rights and access beacon is amazing. And it makes this Michigander very proud. So don't sleep on any state.
I want to thank both of you so much for not just sharing your expertise, not just your insights from the front line, but your inspiration. I am really, truly inspired by your work, by your dedication, by all the fire that you're bringing. So I want to thank you both so much for joining us today. And I want to thank everybody here who's on this webinar for partnering with the ACLU. You are inspiring because by supporting our efforts to mitigate the harm for millions of pregnant individuals, to preserve access by deploying every tool at our disposal and advance reproductive rights at the polls, we are keeping this positive momentum from the 2022 and 2023 election cycles going. So what I hope that everybody takes away from today is that collectively linking arms, we have the staying power to keep fighting until we secure the progress that we deserve and that we demand. So I want to thank you again today for your invaluable support.